is after that, is there a risk of eviction? If any of those steps don't happen, then the landlord cannot evict you. This is an example of a rent demand. This one is actually from 2018. There was a law in 2019 which changed the notice requirements. Which changed the notice requirements from a 3-day rent demand to a 14-day rent demand. Also, one thing you will notice, this green block over here, this is where the rent is broken down into the months that are owed. The landlord cannot just say, you owe me $10,000, for example. They are legally required to say, you owe this much money for April, this much money for May, this much money for June, etc. And they also have to tell you when you have to pay that by. And if you don't, then we will take you to court. In the case where the landlord have gotten a request to enable closed captioning. I don't quite know how to do that. Miriam, is there something that?
Can you say it one more time?
Sorry?
Can you say that one more time?
Sure. I've gotten a request for closed captioning. Is there a way that we can?
Yeah, absolutely. I got that.
Great. Thank you so much. Can you let me know when that's on, please?
Sure. Give me 1 second.
Sure thing.
What I can do is, either way, the presentation is going to be provided. Usually I enable closed captioning. I'm just not able to do that in the middle of the presentation. So I will reach out to that specific person.
Okay. All right.
But you can continue.
Sure thing. Okay, the second most common type of housing court case after a non-payment case is a holdover. A holdover is when the landlord wants the tenant out, whether they owe rent or not. In that case, the landlord must serve a tenant with a termination notice before they serve them with the housing court petition. Just like in the non-payment case, you get 2 notices. The one that notifies the tenant that we are terminating your tenancy, and then the housing court petition. The termination notice has to say clearly, you must move out by some date in the future. If you don't, then we will take you to court. If the landlord does not serve you with that termination notice, then they cannot take you to housing court. This is a very blurry example of a termination notice. The reason I posted this here is I get a lot of calls from tenants that worry that this notice means that they're going to get evicted. It does not mean that they're going to get evicted. What this is the landlord telling the tenant, I don't want to rent to you anymore. I don't have to rent to you anymore. Move out by this date. If you don't, I will take you to housing court. You still have due process rights. You still have to go through all of that process I described at the beginning of the presentation. This is just the first step that the landlord has to take. Now, how much time do you get when the landlord sends you one of these? If you've been living in the apartment for less than 1 year, so between 30 days and 1 year, the landlord has to serve you with the termination notice at least 30 days before they serve you with the housing court petition. If you've been living there for between 1 and 2 years, so more than 1 year, but less than 2 years, then you get 2 months or 60 days before they can serve you with the housing court petition. And if you've been living for more than 2 years, then they have to give you at least 90 days notice before serving you with the housing court petition. So when can the landlord serve me with the termination notice or end my lease? The most frequent circumstances for a holdover case is when the tenant doesn't have a lease and isn't rent stabilized. If you have a rent stabilized tenancy, then you are entitled legally to continued renewal leases. Even if the landlord doesn't send you a renewal lease, they cannot terminate your tenancy unless you are specifically violating a term of your previous lease. Or if you're committing a nuisance, or if you are living somewhere else than your rent stabilized apartment. If you're not living in a rent stabilized apartment, so let's say you're living in a 1-family, a 2-family home, or a 4-family home, or a newer building, then the landlord has to serve you with the termination notice and say exactly the reason why they're terminating your lease. The last, but certainly not the least type of case that is litigated in housing court is called the HP case. This is the tenant initiated case. Tenants initiate cases against their landlords in housing court for unmade repairs or for harassment. Now, one thing that we get a lot of in our intake calls is, my landlord never fixes anything. What do I do? The first thing that it's best for a tenant to do if the landlord is negligent and failing to make repairs is to send them a letter in writing. Snail mail, postal mail is really best. It makes the best record. Email, if you have an email address with your landlord that they respond to, that works as well. Spelling out clearly what the issues are and what you need done. After you send that letter, if there's still issues or if the repairs are bad, then the next step is to call 311 and request an inspection from the City Department of Housing Preservation and Development, or HPD. Now, a tenant can call 311 at any time. There's no, it's certainly not against the law to call HPD without sending the landlord a letter. But in terms of a litigation strategy, if I'm working with a client and their issue is, my landlord doesn't make any repairs, really the best first thing to do for them to have the best position is to start by sending the landlord a letter in the mail, putting them on notice about how exactly they're failing in their duties. One thing that's really important, I know it must seem really impossible right now that it would ever be cold again with how hot it's been, but starting in October, on October 1st, 2021, and ending on May 31st, 2022, landlords have to provide heat for their tenants. What this graphic is saying is that during the heat period, that is between October of 2021 and May of 2022, during the day, that is between 6 a.m. and 10 p.m., if it's below 55 degrees outside, then the landlord has to have heat, bringing the apartments up to at least 68 degrees inside. And during the night, they have to bring it up to at least 62 degrees inside, and it doesn't matter what the temperature is outside. If you think that your landlord is failing to provide heat, I would call HPD immediately and schedule an inspection to confirm that, especially during that key heat period. For between October, the specific months are October 1st to May 31st. So like I said, if, let's say, a tenant sends the letter and nothing happens, then they call HPD, HPD does an inspection. At the end of the inspection, HPD sends the landlord a notice saying that yes, that's correct, there was a violation, and the landlord still doesn't do anything, and the tenant goes to housing court, files an HP case. The best evidence to have is communications in writing explaining to the landlord that, or proving that you have notified the landlord that these conditions exist and that they need to fix them. Pictures and videos of the conditions are also really effective, as well as notes with dates so that you're very clear about what happened when. Also, if you have an HPD inspection and HPD issues violations against the apartment, those violations are evidence. The court, if HPD says, for example, that there's a hole in the wall that the landlord needs to fix, the court will assume that that is true. So that's why having an HPD inspection on the apartment is very helpful for getting those repairs. So, we do recommend that anyone who is really having trouble getting repairs call a legal services provider so that they can get more information about their specific situation. And, you can also just go straight to housing court and do it yourself if you think that you can. Now, a question I get a lot is, should I withhold my rent? The answer is almost always no. That's inadvisable. The reason for that is that it's just really risky that something will happen. The money that you're withholding is not there anymore for whatever reason. And now you're no longer withholding your rent. Now you're just in rent arrears. If you are absolutely sure that you can keep 100% of the rent safe and secure, or if you're in a very well-organized rent strike through a well-established tenants association, then it might be a good idea. But it's really, if you're not in those circumstances, we do not advise withholding your rent to get repairs. Now, I'm not sure if there's anyone here who lives in NYCHA housing. I included a couple of slides about NYCHA housing, which we are already at 12:30, so I won't spend too much time on those. But basically what I wanted to get across was that because of the pandemic and the related restrictions, most NYCHA offices and procedures most physical NYCHA offices are closed, but pretty much everything is still happening online. And if anyone who lives in NYCHA housing needs to do an interim recertification, or for that matter, putting in a repairs ticket, you are entirely welcome to call your management office, and they're really encouraging everyone who can to go onto this website, selfservenycha.info, in order to submit recertifications or repairs tickets or applications or things of that nature. You can also dial this hotline number and pick option 5, and that will connect you to someone as well. Yeah, in about 5 more minutes, we'll pause for Q&A. Another thing to note is that NYCHA is not conducting any new termination hearings until further notice, at which point every new date will be mailed to tenants. Now, this is something that we get a lot in our intake interviews, which is people who move into NYCHA apartments with their family members, and then the family member passes away or leaves for another reason, and then that remaining family member has a very, very hard time staying in the apartment. And the rules for remaining family members staying in a NYCHA apartment is much, much, much more strict than the rules for pretty much any other situation. And it's just so, so important. I cannot impress this on you enough, that if someone moves into a family member's NYCHA apartment, then you need to add them to the household composition. If you do not do this, it is almost impossible to pursue any sort of succession claim after the person moves out. And this is something that NYCHA doesn't seem to publicize as well as it should, considering how many requests we get on that basis. So if you have anyone in your family who have any situations that are even somewhat like this, I just want to evangelize this to as many people as I can. If you're living in your family member's NYCHA apartment, they need to put you on the household composition. You need to create a record of this. Even if they say no, the fact that you asked them will help create a record that a person can use to improve their ability to. We have to have a clear rent before someone can take over the apartment. Let's take some, this is a good time to take some questions.
Okay, great. Okay. So I'm going to start with a NYCHA question just because we're on that subject. So
yes, of course.
Is it true? So an tenant has asked, is it true that you have to have a clear rent before someone can take over the apartment?
They will definitely try and say that. It's, if a person is eligible to live in NYCHA, if their income is below whatever threshold that they have for their eligibility, that person would probably be able to get assistance to cover any rent arrears that exist when they take over. When I have a NYCHA remaining family member case, I'm not really worried about rent arrears. I'm worried about, is that person on the household composition? Because rent arrears it's not to say that rent arrears isn't important. It's very important. It's worth taking very seriously, but it's a solvable problem. There are lots of different ways that a tenant can get coverage of rent arrears, even without something like Erap happening. There are far, far fewer ways to solve a problem, like I'm a remaining family member and I've never been on the household compensation. I hope that answers the question.
Okay, and we're gonna go into the Q&A box. So anyone who has questions, please go to the Q&A chat box. It's gonna be on the bottom hands of the Zoom screen. So I'm gonna go ahead and start with the earliest question from our presentation. So someone's saying, Angie's saying, during the beginning of the pandemic, they failed to pay their rent for 3 months. They have been able to catch up. They have not been able to catch up on the rent, but they have been making monthly payments. Essentially, can this person receive assistance with those 3 months of back rent that they have been unable to pay?
Yeah, absolutely. Assuming that when they say the beginning of the pandemic, they mean March of 2020 or later. As long as they are income eligible for Erap, which I'm going to go into in a second, they can absolutely get rental assistance for those months, regardless of their ability to pay since then. In fact, that's probably a more favorable situation for that person than someone who is still unable to pay their rent going on a year and a half later.
Okay, thank you. Okay, and we have another question from Nancy. How long does it take for HPD to respond and inspect how long does it take for HPD to respond and inspect following a letter to them? Following a letter to HPD, Nancy, or to your landlord? I'm thinking landlord.
Sure. So those two processes are not necessarily connected to each other. Let me put it this way. My ideal repairs client sends a letter to their landlord saying, you need to fix these things in 30 days or I will call HPD. And then they list, I have a hole in my wall, I have a leak in my sink, I have broken tiles in my bathroom. 30 days passes, landlord doesn't do anything. That person calls 311 and says, I would like an HPD inspection. After they do that, HPD usually sends someone to the apartment within a few days, within 3 or 4 days, in my experience, sometimes even less than that. Rarely does it take more than a week to get an inspection, provided that the tenant is there to let the inspector in, of course. If for whatever reason the inspector comes and the tenant isn't there, the tenant doesn't lose their shot. It's not like, oh, you didn't let us in, you're out of luck. You just need to call and schedule another inspection.
Okay, thank you. So Nancy, we hope that answers the question. If not, you can always feel free to add into the Q&A. We have another question from Suzette. Can the withheld rent be put in an escrow account through the courts?
That definitely, yes, you can. I know lots of legal services organizations are willing to hold on to rent for their clients who are in this situation. And in that case, perhaps withholding rent is a less risky decision, but it's still very risky. It's still, I think this last year and a half has shown how unpredictable things can be. And really, you don't want to be in rent arrears. If you're very, very confident that your income is not going to change and you can withhold your rent safely, then go ahead. Or if you're working with a very well-organized tenants association that is doing a coordinated rent strike, then by all means. But if someone is considering withholding their rent, I would really recommend that they would talk to a tenant's attorney, whether that be from Mobilization for Justice or from one of our sister organizations. But yes, I believe the court does do, yes, the court can do an escrow account like that. And also tenants' attorneys can do escrow accounts. I believe even landlords' attorneys are willing to do that. But I mean, then you have to trust your landlord's attorney, which one would rarely do that.
Okay, thank you. Okay, thank you. And we have another question. If you applied for Erap and they emailed you that they received your application, and to show the response from Erap on your court date, I think the question is basically that if a tenant is submitted their application for Erap, they received the response saying, hey, your application has been submitted, but they have an upcoming court date. How can that notification help them to not become evicted?
Sure. I mean, obviously, I'm going to go into that a lot more during the second portion of the presentation, but currently, a completed Erap application should put a stay on any housing court proceeding, non-payment or holdover, any type of landlord-initiated housing court proceeding. What that means is when you go to court and you show your landlord's attorney and the judge, I have a completed Erap application. Here's my 5-digit code. Here's my date of birth. You can confirm this. That should put a stay on any future court dates. So remember what we were saying before. The landlord needs to get a court date and then get an agreement or an order and then a marshal's notice and then an eviction. So this puts a stop on the court date stage. The court will not schedule any housing court case where there's a pending Erap application until that Erap application gets a decision. Also, if you have a housing court date and you don't have a tenant's lawyer, you should ask to be referred to one, because they should be doing that to everyone who has a housing court date.
Okay, so I would say we can spend another 3 minutes on questions. This way at 12:45. How are you, Jesse? You want to take a break?
I'm good. I can take 2 more questions.
Okay, great. So we're gonna go ahead and take 2 more questions.
Sure.
And then
I see a question from Lisa Rosario. I just want to let you know that is you're asking a question that's really specific, and I would recommend that you dial the intake hotline that is going to be at the end of this presentation, and talk to an attorney on that hotline who can give you some more targeted advice. That is to Ms. Lisa Rosario for her question on, it looks like, succession of her apartment by her children.
Yes. Thank you for that. Okay, we addressed that question. Okay, would the same principles apply for holdover, HUD inspection, and Erap apply to those tenants without a lease signed? So what they're asking, I think, is if a tenant, resides in an apartment without a signed lease, would they be able to get a HUD or possibly an HPD inspection? Would the same principles apply in terms of like the legalities of it? I mean, it would. I'll let Jesse answer that, but it would be a month-to-month tenant.
Every tenant has the right to a habitable home. Every tenant can call HPD and schedule an inspection. They do not have to have a lease. I believe that answers the question. Was it referring to HPD inspections or was it referring to ERAP applications? I'm having trouble seeing it.
A little, yeah. So it's referring to both. Yeah, I think just in general, knowing that the tenant still has rights in the apartment,
Yes,
that
that's
they
right.
cannot be evicted just on a whim, just because they don't have a lead sign, they still have to be notified. Sounds like you're a month-to-month tenant.
That is correct. Uh-oh. It's not happening. No. Sorry.
No worries. Okay, we have a few more questions. I think last three questions, we'll go ahead and take that. And then we'll continue because I think a lot of individuals are also asking for ERAP information, and that's going to be addressed in the second portion of the presentation.
Right. I'm going to talk all about ERAP very soon.
Okay, great. So we have one question, Alfredo. What can someone do to prepare for the end of the eviction moratorium?
Well, what an open-ended question. It really depends on the type of case that you have. Currently, as we understand it, every case with a pending ERAP application gets a stay, whether it's a holdover or not. So if a tenant is, if you're worried about the eviction moratorium and you owe rent, then the best way for you to prepare is to submit an ERAP application. If you don't owe rent, if you're facing eviction for another reason, you still have all of those due process rights that I mentioned at the beginning. Your landlord has to serve you with a termination notice or a rent demand notice. Then they have to serve you with a notice of petition and petition. Then they have to get a court date or a default judgment. Then they have to get an agreement or an order. Then there has to be a default on the agreement or the order, and then they can serve you with a marshal's notice. So all of those steps have to be taken. Also, any tenant that goes to housing court that is, you should be referred to a legal services attorney. And if you are not referred to a legal services attorney, you should ask to be referred to a legal services attorney.
Okay. I think the rest of the questions, they're ERAP related. So I'm going to let you go ahead and take over for the second portion of the presentation. So everyone, we are going into the second portion, which discusses ERAP, the application process. We can definitely leave time for Q&A as well towards the end.
Absolutely. Okay, so the COVID-19 Emergency Rental Assistance Program, which I'm going to refer to as ERAP, that's the acronym for the remainder of this presentation. So ERAP is New York State's method of distribution of $2.4 billion of federal money set aside for rent relief. So it's money from the federal government that's been earmarked for New York, and ERAP is the way that New York is distributing that money. It's earmarked for tenants who are making 80% of the area median income or less. What that means is if you are in a household of one, then you have to be making $66,880 a year or less. If you're in a household of two, then it's $76,400 or less. Household of three, $85,920 or less. Household of
Abby.
four, hello?
Sorry about that, guys.
Oh no, all good.
Do you hear me? Yeah, sure. I'm gonna mute myself, sorry.
And then it goes up from there. So as that's a very high income threshold. It's definitely higher than our representation thresholds. So really most people who are behind on rent should be eligible for ERAP as far as income limits are concerned. The tenant or occupant must be obligated to pay rent and primarily reside in New York State. And they have to have either qualified for unemployment or otherwise experienced financial hardship during COVID-19 and are at risk of homelessness or housing instability. And I will explain what each of those mean as over the next few slides. Now, what does it mean to be obligated to pay rent? Obviously, if you're a tenant with a lease and it's current, then you're obligated to pay rent. However, you do not need to have a lease to be eligible for ERAP. If you had a lease but it expired, or if you just had a month-to-month agreement, even if it's a verbal agreement with the landlord to pay rent, you are still eligible for ERAP. The way that you prove that, if you don't have a lease, you can show proof of prior rent payments. This can be money order receipts, a redacted bank statement. If the landlord sent you a breakdown, that notice to pay rent that I was discussing earlier, that shows that you have an obligation to pay rent. So anything in writing that shows that you have an agreement with the landlord to pay rent for a housing unit. The tenant also needs to show that they have experienced financial hardship during COVID-19, which is to say from March of 2020 until the present. Obviously, the most clear form of financial hardship is receiving unemployment. If you are or were receiving unemployment for any of that period, then proof of that is sufficient to show financial hardship. If you're one of the many people who have not received unemployment because of the nature of your job, or that the nature of the financial hardship didn't necessarily make you eligible for unemployment, you can show that you had reduced hours at work, or you worked for a business that closed, or you became sick and were unable to work for a period of time. All of that is enough to show that you had a reduced income due to financial hardship. The other way that you can show financial hardship is through increased costs. Because often, we all know that for many families, even if they didn't lose their jobs, there was a whole lot of other stuff that went on that made people unable to pay their rent for some period of time. So if as many of us, myself included, had a death in their family this year, showing that you had to pay those funeral costs or healthcare costs, that is a financial hardship as far as ERAP is concerned. If a family has children and those children are no longer attending school and they had to take on additional expenses to set their kids up with remote learning, or additional childcare expenses if they had to continue to commute to work and their child had to stay at home, if they had additional work expenses, if you had to buy any equipment because you were working from home, or any additional transportation costs, or caring for sick relatives, or if you had to make additional credit card or loan payments to pay rent and avoid homelessness, all of that is also sufficient to show financial hardship for ERAP. So the only way that it wouldn't apply is if the person had no risk of housing instability, suffered no financial hardship, or this edge case where if the household is all college students, and at least one is a dependent on their parents' tax return. If you're in a household of all college students and all of them are independent adults, then they are still eligible for ERAP. But if you think you might be in that situation, I would recommend that you just call my office's intake hotline and we can provide you with more targeted advice. So everyone that applies has to submit certain documents that prove their eligibility. The first form of documentation that everyone needs is some form of identification. Now, this can be a driver's license, a passport, a birth certificate, a state or city ID card, a benefits card, or a school registration. Every tenant with a social security number will have to provide that social security number. If you don't have a social security number, for whatever reason, you do not have to provide it. You are still can be eligible for the program. I've had clients who have proven their eligibility by submitting a tax ID number. But ERAP is willing to work with, they do not ask you for your immigration status, and they are willing to work with people who don't have social security numbers and need to figure something else out. So that's very important to know. You also need to prove that you owe rent and how much. The easiest way to do that is with a signed lease, current or expired. You can also submit any rent receipt or canceled check or money order. If your landlord is taking you to housing court, they should have provided you with a rent breakdown. Most landlords' attorneys it's pretty easy to get a rent breakdown from them because they know that that's the best way for them to get paid. But if you cannot get any of those for whatever reason, perhaps you are living in a two-family home and your agreement with your landlord is very informal, a signed notarized statement from the landlord should be enough as a last resort. So definitely a lease or a rent breakdown is definitely preferable, but if for whatever reason it's impossible to get any of those, then a signed landlord statement should work as a last resort. You also need proof that you live there. If you have a lease, either current or expired, that will, a lot of the documents that you can use to prove that you owe rent and how much, obviously also prove that you live in the apartment. You can also show that you have utilities coming in your name to that address, school records, a bank statement, or if you have nothing else, then postal mail with the name of the applicant on it, connecting them to that address. This is especially important when the person applying is not the person whose name is on the lease. Whether that be because the person who's on the lease has passed away or no longer lives there, or something else, and the landlord isn't putting the applicant's name on anything. Providing those documents that connects you with that address is really important. Then it also has to provide proof of income to show that they are within those income thresholds that I mentioned before. Proof of income can be either the current income for the prior month, whether that's a pay stub, a bank account deposit, or if the person is not getting any, if you have no income right now, a benefits letter, an unemployment letter, or if you have neither income nor unemployment, then a statement from HRA, showing how much you are getting in benefits every month. You can also submit documents showing your annual income for the year of 2020, whether that be a W-2 or a filled out income tax return, or if none of those options are available, if the applicant is self-employed in a cash business, a written and signed statement is what they recommend submitting. Now, once you submit all those all those documents and the application is complete, Erap can cover up to 17 months of rent going back to mid-March of 2020. That is to say, any missed rent starting at mid-March of 2020 going all the way up to now, August of 2021. If the tenant proves that they are still rent burdened, Erap will also pay up to 3 months of future rent. So that is to say, if you submit your application now in August of 2021, and you have 17 months of back rent, Erap will pay those 17 months of back rent. If you can prove that you're still rent burdened, they will also pay September, October, and November 2021 rent as well. Now, Erap also will pay utilities arrears. Some things to note about that. You can apply for utilities assistance by submitting the most recent utilities bill that shows how much you owe for that utility. They will pay up to 12. No, I believe that's incorrect. It's the same as the rent from March of 2020 to the present. So 17 months of electric or gas only for arrears that have accrued on or after March 13th, 2020, if and only if the household also applies for rent payments. So if you don't owe any rent, but you do owe utilities, you are not eligible for Erap. Tenants can only apply for utility arrears payments if they also apply for the rental assistance. And same thing as before, if the utility bill is in the name of someone who is not currently living there, you should still submit the most recent bill that shows how much you owe and confirm that you live there and that you're eligible for payment of that bill by submitting whatever it is that you have that connects you with that address. Okay. It's administered by the New York State Office of Temporary and Disability Assistance. Applications will be online, and they are available in English, Spanish, Chinese, Russian, Korean, Yiddish, Haitian Creole, and Bengali. And like I said before, if you are currently in housing court, proof of a completed Erap application should put a stay on your case until you get a decision. So if you go to court, whether that be in person or virtual, and you submit the 5-digit Erap code, your date of birth, then the court should put a stay on the case and not schedule any additional court dates until you get a decision. And this is the website to apply. Something that I'll add this to the presentation after I'm done. So we are starting to get decisions. So far, they've all been positive. At least the ones that we have submitted for clients have been positive. But if the tenant gets an Erap decision and it is wrong, you have 30 days to appeal that decision. And you can appeal by calling the hotline posted on the website, requesting the appeal and getting a confirmation. And then after you get that confirmed, you have 10 days to upload any documents to prove that their decision is wrong. That is what would happen if they deny your application and you think that they should not. If you have any specific questions about this, or if you have a particular situation that needs legal advice, everyone is welcome to call our Brooklyn tenant hotline, which is 212-417-3888. And we are open on Monday, Wednesday, and Thursday from 9 to 5. That hotline is staffed by attorneys, by tenants' attorneys specifically, and we can provide immediate counsel to any particular situations that you're in, as well as assessing you for possible representation later. And we actually have a lot of time for questions.
Hi, everyone. Okay. So we have some questions coming in the Q&A. Okay, this one. So Ray, for the questions that are written in Spanish, can you please interpret that for us? I included that in the chat as well. Okay, I'll address that question last. Maria Arenas, I'm gonna get to your question last. So we have a question saying, can an undocumented person apply? I have 4 kids that are American citizens, but because the head of household doesn't have a social security number and they're unemployed, they don't know if they're eligible.
Yes, undocumented people can apply. Erap does not ask for your immigration status. If you don't have a social security number, and you have not filed tax returns, it's worth it to call in and explain the situation, and they will help you, and they will help you troubleshoot that. I have found that the people working at Erap are actually quite helpful. They pick up the phone very quickly. You're not on hold for very long, and they will explain their procedures and how you can troubleshoot a particular issue. I do know that undocumented tenants do not have to, or sorry, undocumented tenants are still eligible and do not have to submit social security numbers. I've had undocumented clients submit tax IDs instead. If you have neither a social security number nor a tax ID, you'll probably need to submit some sort of statement explaining what your situation is and how you have been economically impacted by COVID-19, but it is doable. Yes, undocumented tenants can be eligible for Erap.
And someone is asking, do you qualify for Erap if you don't owe rent, but it's still a financial hardship to pay rent, as most of your income goes towards rent because of insufficient amount of income? So Erap doesn't cover rent moving forward. That's more of a subsidy question.
Yes, that's right. Yes, if you do not owe rent, then you are not eligible for Erap. If you are extremely rent burdened, there are subsidies available that would be worth investigating. And it would be, I would say the best thing to do is to call to set up an appointment or a pre-screening call with your local, with your nearest Human Resources Administration office, and to see if there's any subsidies that you would be eligible for.
Yeah, and I would say if you're not in rent arrears, I mean, the main way that I've seen subsidies being administered is at the very end of a possible eviction. The point of such subsidies like city FEPs is to basically provide that ongoing support if you're deemed eligible, and that usually requires having a notice of eviction, being at risk of eviction, sometimes to the point of having a marshal's notice on the door, but that's usually the extreme end. All right, and how long does it take for Erap to accept the application for starting payments for your rent? So I think Jesse, you referred to that time frame.
Yeah, it's been taking a long time. They are doing a very, very poor job of actually making decisions on applications and distributing money. The community of legal services attorneys are very, very frustrated with the people who are in charge of Erap because they're not doing a very good job. But decisions are coming in now in late August for the applications that were made in June of this year. So it's just getting started, and it's taken 3 months for the first decisions to start coming in, or about 2.5, 3 months. Probably that's going to get smaller as they and as they make decisions, they'll be able to make more decisions more quickly. But that's why it's so important that you are all tenants who have made Erap applications clearly show their landlords and their housing court that they've made it, so that they can get that stay put on their housing court case. But it is taking some time, and that's very frustrating. It's very burdensome on tenants, and we are all very annoyed by that.
Yeah, likewise. I think as long as you put in the application and you just have documentation, that's pretty much key. If the decision is just pending Erap's response, I wouldn't fret too much about it. Somebody had asked a question, sorry, about missing their court date, potentially, I believe. And I let them know that they can submit an order to show cause. It's an OSC. That's also applicable in the case, let's say, if you haven't received, I think, in your rep response, but you can expand on that, Jesse.
Sure. To be honest, that person should. I guess I'm not clear whether this person is asking about a court date that they have already missed, or a court date that they anticipate missing because of a scheduling conflict. If it's the latter, all court appearances should be virtual anyway. But that person should call our intake hotline and set up an appointment with us, and we can help them through that. Because to be honest, the recent Supreme Court decision from about a week ago has thrown the conventional wisdom about default judgments, especially, a bit up in the air. So if anyone is worried about default judgments, they should call our hotline and talk with an attorney one-on-one.
Yeah, so I'm just letting them know. Thank you for that. And the question from Maria Arenas is, do they qualify for Erap if they're renting a room?
Yes. Yes, they are. You have the same proof requirements as anyone else. If you don't have a written agreement with the sub landlord, then you can provide a written statement from them from the person that you're renting the room from, saying this person owes this rent for me for these months. Depending on depending on the relationship with the person you're renting from or your own economic situation, it might be better to have the primary tenant, the person that you're renting the room from, fill out the application for the whole household, because there is a portion of the ERAP application where roommates submit their own economic status. But that, if we're getting into that level of specificity, that person should just call the intake hotline and talk to an attorney one-on-one.
Okay. I'm going to answer one of the other questions, or I'm going to ask one of the other questions from a Finnish speaker who is in the chat. They asked, can you make 2 applications for payment of overdue rent in the same year? I'm not sure if this is referring to ERAP, but I believe ERAP is just 1 application.
Yes, that's right. I guess there was an earlier rent relief program in 2020. And if that's what the person is referring to, then yes, you can still be eligible for ERAP if you applied for that earlier program from last year. But if you have already submitted an ERAP application and you have not gotten a decision yet, you should be able to call in and amend the application by submitting new documents showing that you owe rent for, let's say you applied in June and now you also owe rent for July and August. If you call in to the ERAP hotline and explain this to them, they should explain to you how you can amend the application to include those later months of rent without submitting a new one. I hope that answers the person's question.
So another person's asking a question. They are being harassed by the owner of the building who does not want to renew their lease. And they are not accepting their rent. I believe they're in a rent controlled apartment.
Okay, if you're in a rent controlled apartment, then you are entitled to renewal leases every year or every 2 years. You still have the protections of rent control, whether your landlord gives you a renewal lease or not. If they have a specific reason for trying to evict you, whether that be because you are violating the terms of your lease, allegedly, or something else, they have to notify you of that. But this person should really call the hotline and talk to an attorney one-on-one.
Okay.
But if you have a rent stabilized or rent controlled apartment, you are entitled to renewal leases as long as the apartment remains rent stabilized or rent controlled, and you retain those protections regardless of whether the landlord renews your lease or not.
Okay, we have about 3 more questions, and I think that's perfect timing. I just want to also say that the slides will be attached in an email sent by myself, as well as a flyer for Sinergia's housing advocacy services. And if there's any further questions, you can feel free to, they're more specific, you can feel free to call the Mobilization for Justice hotline. So the number is 212-417-3888. That's going to be included in the email correspondence. But if you're not, communicating with us via email, I would just say to give me a call, if anything. If you called in, I'm going to type in my number and extension in the chat. And this way you can reach me for the information. But for the most part, we are also on Facebook Live. And that presentation is, I've been able to close captioning, and that will be up. So I'm going to move on to the questions. So what if the tenant had no financial hardship, just decided not to pay the rent? Can the tenant apply for Erap?
They can try. Truthfully, we are only just starting to get applications coming in. So we're still learning how strict OTDA is going to be about what level of financial hardship is necessary to be eligible. However, there is no penalty for applying to Erap once and being being mistaken about one's eligibility. If you get a negative decision, that just means you don't get the rental assistance. You are still entitled to the stay of your housing court proceeding until the decision on the application comes in. There's lots of different ways that a tenant can show economic hardship. It doesn't have to be lost their job. They can show increased costs in any of those ways that I described previously.
Okay, great. There's another question. What if a person has received an eviction notice in the past? Are they eligible for a subsidy? I mean, if you're talking about, I'll address this to the best of my knowledge, and then you can definitely correct me, Jesse. But in terms of if you're going through the route of going to home base, every community borough has a local home base organization that serves specific zip code areas. So if you're going to home base with something that is from the past, you wouldn't be eligible for a subsidy moving forward. So yeah, that's just something really general. But Jesse,
yes, that's right. I guess it depends on if the caller is referring to, I got an eviction notice 2 years ago, and then I resolved the issue, and now I'm falling behind on rent again. And in that case, yes, you should be able to apply for Erap, no problem. And the previous eviction notice should not negatively affect their eligibility for any other more durable subsidies. If the person is talking about, I got an eviction notice in February of 2019, and I don't know what's happening in my case right now, that person should call the Mobilization for Justice hotline and set up an intake with us so that we can provide them with more targeted assistance. Because in that second case, it's worth monitoring that very, very closely. But if it were in the first case where 2 years ago, 3 years ago, my landlord took me to housing court and it got to the eviction notice stage, but I got it all paid and now it's over, but now I'm in trouble again, yes, that person can apply for Erap. There's no problems with that.
So there's a specific question, but it's also super applicable, I think, for anyone who's listening right now. What if the landlord who submitted the Erap application put the total is incorrect, and the tenant, isn't getting a breakdown? It basically says the amount that the landlord says I owed, which is submitted, is incorrect. So how would they be able to address that?
I mean, if you can, I guess it really depends on what that tenant's situation is in terms of their lease and what proof they have to show that they owe certain rent. And And it also depends on whether that person is talking about the landlord asking for more than they need or for less. If it's less, then and the tenant cannot prove the landlord wrong by submitting a rent breakdown or something else, I, as an attorney, would argue very strongly that if the landlord is saying that they owe, that they are entitled to, say, 3 months, and then in court they say no, the tenant actually owes me 6 months. I mean, the landlord admitted in the Erap application that they only owe 3 months, so they can't collect the other 3 months. If it's the reverse and they're asking for more than they're entitled to, I mean that and the tenant can't submit written proof that proves the landlord wrong, that person should probably just call the intake hotline and talk with an attorney one-on-one, because then then we're getting into like really specific situational cases.
Yeah, I've actually included that in the written response as well. I think that specific. So Verna, if you can call the hotline I don't know if it's on behalf of a client or on behalf of yourself or a community member, definitely try to connect with the hotline from Mobilization for Justice. Last two questions. Will the tenant be notified when will the landlord be notified when a tenant applies for Erap?
Yes, the landlord, so once a tenant completes their application, Erap reaches out to the landlord and basically has the landlord upload some documents that they need to confirm what the tenant is saying and how much they are owed, and to confirm the landlord's identity and that they are actually providing a housing accommodation to this tenant and that they actually own the building that they are renting to them. So yes, the landlord will be notified that a tenant has submitted an Erap application.
Okay, and we're getting a question, and it's about funeral costs and daycare costs considered as part of a financial hardship. So I know that you had addressed this in the middle of the presentation, but I believe as long as the hardship is related to rent hardship, and it can be tied and you have documentation, it would be considered.
Yes. Funeral costs and daycare costs are explicitly stated as eligible financial hardships due to COVID-19. And the person who you paid for the funeral of does not have to have died of COVID-19. You just need to show that you paid funeral costs.
Okay, and just a final question there. It was already addressed partially, but a community leader from East Harlem was asking, what are agencies that can provide Erap assistance? So I wanted to put a plug in that Sinergia, if you call our intake line, we are able to provide Erap rental application assistance for individuals that reside between 96th Street and 126th. So it's a very specific area, but it does cover a lot of East Harlem. And with that being said, we also can provide services for people who have one member in the household with a disability. And when we say disability, we mean intellectual and developmental disability. They would be eligible through the New York State Office for People with Developmental Disabilities. The acronym is OPWDD. And again, calling our intake line, and we serve all boroughs within that particular program. And Jesse, if you have any recommendations, organizations that you know of.
I mean, I think if you have a home base or Canva office that is nearby, I believe also going on the Erap website and calling their number and asking if they can refer you to organizations that will provide that assistance as well.
Yeah, I'd say that because a lot of organizations were given a notification if they wanted to become ERAP representatives, and they would receive, I believe, specific training on that. So there are certain organizations that are able to do this via ERAP through a contract with them. But for the most part, calling the ERAP hotline is the best bet to get a list of maybe local places near you. If you aren't savvy with doing things over the telephone or on the computer. But yeah, I hope that this webinar addressed a lot of the questions. We have one more question, but I am going to include that. I'm gonna include that in an email to you, Jesse. Just it's one pending question. But essentially, it's around the same thing. Sorry, I'm just trying to get into the nitty-gritty of it. I like addressing these questions. I think this was a really productive session for everyone. But let me just make sure that I keep this question in so that I can send it over. And I also want to take this time to thank everyone who participated. I know this is a tough time, so I hope that this webinar was able to give you some ease, even though things are still really uncertain. I want to thank Jesse from Mobilization for Justice and the Mobilization for Justice team and all the pro bono legal attorneys that are working tirelessly with like all this new information that's coming in. Thank you so much, Jesse. And Ray, thank you for being our interpreter, for bridging that linguistic gap, and for making sure that people get information that they need. Thanks. He's given a thumbs up for everyone.
Thank you, Miriam. Thank you, Ray. Thank you, everyone, for coming, and solidarity out there.
Yeah, absolutely. So I'm going to go ahead and conclude this webinar. I will be sending a post-webinar survey. If anyone has questions, you can feel free to contact me. Again, if you registered, you're good. You'll receive that information. All right. Have a good one, everyone. Thank you.